Hey y'all, thank you for joining me on this episode of 15 Minutes of Murder, Ask a PI. This time around, I have decided to kind of walk y'all through the process from when you are arrested up until the end of your trial. But before I say another word, let me lay down this quick disclaimer that I am not an attorney. I am not authorized to give legal advice, and everything you finna hear is for educational and informational purposes only. All right. With that being said, before we go further, click that subscribe button. You know why. Without it, how do you stay tapped into me, Desiree Edwards, the 15 Minutes of Murder, resident crime expert, and everybody's favorite PI? Y'all know that by now. But also, clicking that subscribe button means growth. And what does growth mean? Better, stronger content that we could provide to our viewers. All right. With that business handled, let's get down to this PI business. So you have been arrested. You're in the back of a squad car. They're hauling you off to a detention center. What happens? Well, depending on the time of day or even the day period that you have been arrested, within 48 to 72 hours, you will go before a judge to be arraigned. What happens at your arraignment? Well, a few things. Number one, the judge will read you your rights. The judge will go over the charges that you have been charged with. A judge will, talk to you about getting an attorney. Do you want to retain an attorney or do you want to accept a public defender? Now, leave me a comment in the comment section because I want to come back to y'all and explain to y'all why a public defender is always my preferred go-to. I know it sounds crazy because for somehow in the media, the movies or all of that, these public defenders got a bad rap. But if you're interested in knowing why I prefer public defenders, leave me a comment and I'll come back and talk about that. Okay. But let's keep going on about this arraignment. So they're asking you about your attorney, but also this is where the judge will discuss any bond or bail issues that you have. The judge, did I say that the judge will enter into um, a not guilty plea for you? If I didn't, let me just say it again. Um, the judge will probably enter into a not guilty plea, say that the defendant stands mute, not guilty. Okay, and that's for obvious reasons. What are you pleading guilty to when you haven't even heard the case against you? Okay, so that is merely to preserve your rights. And I know as the public, when we are watching the news and we hear someone yell, oh, he pled not guilty. Of course he pled not guilty because he don't know what he been charged with just yet, right? Okay. So the arraignment is over. Oh, let's go back one quick second. The arraignment has to happen between 48 and 72 hours of your arrest. If it does not happen, they have to release you and drop those charges. If none of those things happen, then it is time for you to consult with a civil attorney. And that's just real talk, y'all. Don't we got to be careful. And that's why I'm here. I want to give y'all some information so you kind of have a better idea of what your rights are and what to expect during this process. Okay, so you have been arraigned. The judge has entered a not guilty plea on your behalf. You got your little court appointed attorney. Why? Because Des says that's best. We're going to come back to that. But you are out in the world. You, your attorney, and your investigator are now in a position to prepare you for your preliminary examination. And what is the preliminary examination? We're going to talk about it. That is essentially the mini trial. This is where the prosecutor goes before the judge and presents some of the information that they have um, to justify these charges against you. They may call in some witnesses, the police, they may call in just other people, might even be the victim, but these people get to testify before the judge. Now, this is a very strategic hearing, and it kind of has pros and cons for both ends. So now the prosecutor has set forth their witnesses. Now, the defense attorney is hearing these witnesses testify. So, if the prosecutor uses any of these witnesses at trial, and at trial, these witnesses say anything against what they said at the preliminary exam, now the defense attorney gets to attack that testimony, impeach that witness, which then, therefore, decreases the credibility of the prosecutor's case. But what also happens at this preliminary exam, if held, is that the defendant is now at risk of having the prosecutor bring more charges against them. So it's kind of strategic on both halves. Both of them can benefit, and both of them can take a loss. So we got the defense can take some kind of benefits from being able to impeach these witnesses, but the prosecutor gets the benefit of saying, hold on, we found some more stuff. We finna add this to the pot, judge. And then the defense attorney has to decide whether or not they even want to hold the preliminary exam in the first place. Because on some real talk, um, it might not be worth the risk to bring the client before the judge, hear all this information, and then now the prosecutor has a way of adding more stuff. Okay. So now the judge is hearing everything that's going on at this preliminary exam. And then now the judge is in a position to decide if they want to bound the client over for trial or if they want to dismiss the charges. So the judge may say, look here, prosecutor, this is lame. Y'all ain't got enough. Get this out my court. Release this person. Or the judge may say, prosecutor, y'all got some hot stuff over there. We finna go to trial. Now, if the judge decides that we're being bound over for trial, the case will then be dismissed at that lower court, which is the district court, where the arraignment and the preliminary exam are held. And if you are bound over, now you're going to be kicked up to a higher court, which here in Michigan is called a circuit court. And this is where I tell my clients, we finna get war ready. And what I mean by that is now I am about to pursue witnesses because the prosecutor just told me what we need to know. We know how they coming. So now I get to form my defense strategy from these witnesses because I now have a better idea of what we're up against. So now I get to pursue witnesses. Now I get to pursue exculpatory evidence. And what is exculpatory evidence? Well, that is just a $10 word to say Des is going to find evidence that is going to help the client. All right. So 2 weeks after, about 2 weeks after your preliminary exam, you come back to court for an arraignment of information. What is that? Well, now that you have been bound over, and you're in this higher court and you're getting prepared for trial, you have to go before the judge to have all of the charges at this new court, this higher court, this trial court, formally read to you. So it might be the same charges as before if the prosecutor did not decide to add charges. But if the prosecutor decided to add charges, now the whole bulk of the charges are now read before you. So we working now, right? We're getting closer to the goal. Generally, somewhere in there, that trial date is set, but that trial date comes a lot further down the line. Before we get to trial, there's a whole lot of other dates in between there that we got to get to. Now, at this point, the client's nerves and head is swirling because what is happening? And so, as a support member of the defense team, this is where I step in and kind of explain to them what happens. So, before we get to trial, there is a series of dates, a bunch of them, and this could take years. People always ask me, well, Des, how long can it take? And I always tell them, I'm not trying to be cute or smart mouth when I say this, but it literally takes as long as it takes, y'all. So some of those court dates that you have before you go to trial are things like motion hearings, disposition conferences. You're going to have a series of pre-trial conferences. And so as the client is trying to figure out what it is, what these dates are, I kind of just tell them, calm down and listen to the words that are being said to you. So a disposition conference, that is a court date where attorneys come together and they try to figure out some kind of resolution. It could be dropping some of the charges, it could be coming up with a plea agreement and a suitable sentencing guideline that the defendant and the prosecutor can agree with. But whatever it is, that is what a disposition conference slash hearing does. It is trying to come up with a way to dispose of these charges. A motion hearing, it is just that. It is a hearing where both attorneys come before the judge and the judge hears these motions. It could be motions to quash, it could be motions to drop the charges, it could be all kinds of motions. I don't know what these attorneys be doing, but that is what a motion hearing is for. Pretrial conferences are just that. It is a series of dates that you have before your trial. Sometimes it is a map. I refer to them as actually housekeeping dates because to me, that's kind of what it is. The attorneys are in court deciding on who has what discovery, trying to be sure if everyone's schedules are still in place so that we're on track. It could be even more plea negotiations. Um, but it is a series of court dates that we have leading up to trial. Another date that I believe I mentioned would be a calendar conference, which again, conferences to discuss these schedules. Are we still on track? Who has a vacation? Who has a sick kid? All of that kind of stuff. And you go through all of those things leading up to trial. Now, once you get to trial, it still ain't too late. If you like, no, they got something on me, Mr. Defense Attorney. Des, I know you did your thing, but I don't want to risk it. So it is still time up until the jury is seated for the defendant to decide if they want to go ahead and accept the plea. But that is if the prosecutor is willing to even negotiate at that point. Okay. So now we're at trial. We got the jury seated. Both attorneys doing their thing, going back and forth. Sometimes I may be called to testify. Most times the attorneys like to keep me as far away from the court as possible during trial. Other times, yeah, I get up on the stand, and this is where that expert testimony in Des comes into play. What will I testify for? Whatever it is that the attorney needs me to be. It may be that a witness who I interviewed had taken the stand before me and said something completely different, and that attorney may argue to have me come before the court and testify to actually what was said to me. So it kind of depends on how that attorney wants to use me. But we're in trial. The jury has heard both sides, and then they come down with the verdict. Sometimes it's split, sometimes it's not guilty, sometimes it is guilty. But that is what we have the jury for. They make that decision. The judge, once the jury has made their decision on guilt, the judge then imposes the sentence. But hold on. Not everyone chooses to have a jury trial. You can have a bench trial. Now, I don't necessarily think that's a good thing. And most attorneys don't either. But again, I ain't here to give you no legal advice. I'm just here to give you information, okay? But that's what we got. And oh yeah, again, if you want to know why I prefer a court-appointed attorney, drop a reminder in the comments for me to do a Ask a PI to talk about my take on court-appointed attorneys and the care that they give to clients. Okay, but that's it for now. Thank you for joining me. Be sure to catch me on the next 15. I'll see you then. Talk to y'all later. Good night.